Rest of Immigration and Customs Enforcement. This is a worksite inspection. All employees stay where you are. I need to see employment documentation
I need to get my
for your
manager?
entire workforce immediately.
I need to get my manager. One moment, please.
Get whoever's...
Reyes Construction and Development had been operating out of the same building on Carpenter Street in San Antonio, Texas for 19 years when they came through the door. Thursday morning, 9:12 a.m. The kind of South Texas heat that arrives before breakfast and stays until long after dark, where the air sits heavy with humidity and the smell of cut lumber and concrete dust and honest work. Roberto Reyes had been at his desk since 7, reviewing subcontractor bids for a municipal drainage project his company had won 3 weeks earlier, the largest public contract in the 19-year history of the business he had built from a single pickup truck and a license. 58 years old, reading glasses on, coffee going cold beside his keyboard, wearing a plain white Guayabera shirt and dark slacks. His company employed 41 people. His office walls held 19 years of framed project photographs, community service awards, and one document in a dark wooden frame that he had never moved and never would. His certificate of appointment as an immigration judge of the United States Department of Justice, signed by the Attorney General, dated 26 years ago. 3 ICE agents walked through the front door of Reyes Construction at 9:12 a.m. and did not see that frame until it was far too late. The building's security camera system, 8 cameras covering every interior and exterior angle of the 2-story structure, captured everything from the moment the unmarked government vehicle pulled into the parking lot. Lead Agent Victor Harmon stepped out first, followed by Agents Castillo and Webb. All 3 in full tactical vests with ICE identification patches. All 3 with body cameras rolling. All 3 moving with the particular efficiency of people executing a plan they had prepared the night before. The plan did not include a warrant. The plan did not include a specific named target. The plan was a worksite raid based on an anonymous tip alleging undocumented workers at a Latino-owned construction company on Carpenter Street. What the plan did not include was any research into who owned that company. Before we continue, where are you watching from? If this is your first time here, you need to hit that subscribe button. Stories like this one don't get told unless we tell them. And your support means these videos reach the people who need to see what is really happening out here. Harmon pushed through the front entrance first. The lobby camera captured his entry clearly. Tactical vest, badge visible, body camera active. The posture of a man who expected the space to rearrange itself around his arrival. The front desk receptionist, a young woman named Diana, looked up from her computer with the particular expression of someone who has never seen 3 federal agents walk through a door before and is trying to decide if this is actually happening. Immigration and Customs Enforcement, Harmon announced, his voice carrying through the lobby and into the open office space behind the reception desk where 3 staff members had looked up from their desks. We are conducting an inspection of this worksite. All employees are required to remain where they are. We need to see employment documentation for your entire workforce immediately. Diana stood up from her chair. Sir, I need to get my manager. Get whoever is in charge, Harmon said, already moving past the reception desk toward the open office space. Castillo moved left toward the corridor leading to the back workshop area. Webb positioned himself near the entrance, blocking the exit. The lobby camera captured all 3 positions simultaneously. The operation had taken 11 seconds from entry to containment formation. Roberto Reyes heard the commotion from his office at the end of the second-floor corridor. He heard Diana's voice, strained and uncertain. He heard Harmon's command carrying through the building. He removed his reading glasses, set them on his desk beside the cold coffee, and stood up with the particular deliberateness of a man who has spent years in a courtroom and knows that the first thing you do before you speak is make sure you are steady. He walked out of his office and down the stairs. The stairwell camera captured him descending, unhurried, measured, his hand light on the rail. The lobby camera captured him arriving at the bottom of the stairs and seeing the 3 agents for the first time. His expression did not show surprise. It showed recognition, not of the agents specifically, but of the situation, the formation, the posture, the energy of an operation that had already decided what it was going to find before it found anything. He had seen this from the other side for 16 years. Harmon turned when he heard footsteps on the stairs. He looked at Roberto Reyes. A Latino man in his late 50s in a white guayabera shirt and reading glasses pushed up on his forehead, and saw exactly what he expected to see when he walked into a Latino-owned construction company on Carpenter Street. He did not see the frame on the wall at the top of the stairs, the certificate of appointment, the Attorney General's signature, the dark wood frame that Roberto Reyes had never moved and never would. "Are you the owner?" Harmon asked. "I am," Reyes replied, stopping at the bottom of the stairs. His hands were at his sides, visible, relaxed. "Roberto Reyes, I own this company. Can you show me your warrant?" Harmon's chin lifted slightly. "We are conducting an authorized worksite enforcement operation under Federal Immigration Authority. We don't require a warrant for a worksite inspection." Reyes looked at him steadily. "Yes, you do." The lobby camera captured the brief silence. "Sir, I need you to produce employment documentation for your entire workforce." Harmon's voice carried the flat certainty of someone who expected that sentence to end the conversation. "You need a warrant to inspect my employment records," Reyes said. I-9 documentation is protected from warrantless inspection under administrative search doctrine. You need either a judicial warrant, an administrative subpoena issued with proper notice, or my consent. I am not consenting. Do you have a warrant or an administrative subpoena? Harmon looked at him the way people look at someone who has said something unexpected in a language they almost recognize. "Sir, this is a federal enforcement operation." "I know what it is," Reyes said quietly. "I presided over immigration proceedings for 16 years as a United States immigration judge. I am familiar with the legal framework governing worksite enforcement operations. You do not have the authority to inspect my records without a warrant. You do not have the authority to detain my employees without individualized reasonable suspicion. And you do not have the authority to remain on these premises past the entrance without my consent or a court order." He paused. "Do you have either? Should federal agents be permitted to raid businesses and demand employment records without a warrant based solely on anonymous tips? Comment below. Because what happened inside Reyes Construction that Thursday morning was not an isolated enforcement action. It was a window into what happens when federal authority assumes that a Latino business owner on Carpenter Street will not know the law well enough to name it. Harmon took one step forward. "Sir, I am going to need you to step aside and allow us to conduct." "Agent Harmon," Reyes said, reading the name from the badge with the practiced precision of a man who spent 16 years identifying himself for the record before every proceeding. "I am going to tell you very clearly what is happening right now. You entered this building without a warrant. You began issuing commands to my employees without a warrant. You have dispersed your team through my private business premises without a warrant. Every second you remain past this point after I have withdrawn consent is an unlawful presence on private property. I am formally withdrawing any implied consent granted by your entry through a public-facing door. You are now trespassing unless you produce a warrant." Castillo had come back from the corridor. The lobby camera captured him rejoining the group, his expression uncertain. Webb remained near the entrance, his body language no longer carrying the confidence it had 11 seconds after entry. Harmon's jaw worked. "We have authority under produce the authority," Reyes said. "Show me the document, a judicial warrant, an administrative subpoena, or a consent I have not given you. One of those three, right now, in my hand." Silence. The lobby camera recorded it. 8 seconds of silence in a construction company lobby on Carpenter Street while a retired federal judge waited for 3 ICE agents to produce paperwork they did not have. Harmon reached for his radio. He called his supervisor. The lobby camera captured his side of the conversation. Terse, clipped, the voice of a man reporting a situation that was not developing the way the briefing had suggested it would. He used the phrase uncooperative business owner once. He did not mention that the business owner had cited the administrative search doctrine by name or that he had asked for a warrant 3 times in under 4 minutes. While Harmon was on the radio, Reyes walked to the reception desk, picked up the desk phone, and made 2 calls. The lobby camera captured both. The first call was to his attorney, a civil rights litigator named Patricia Vega who had her office 6 blocks away and was at Reyes Construction in 11 minutes. The second call was to the San Antonio Field Supervisor for the Department of Justice Office of Professional Responsibility. He had that number memorized. Patricia Vega arrived at 9:31 a.m. The exterior parking lot camera captured her car pulling in, captured her walking through the entrance 19 minutes after the agents had entered, a woman in her early 50s carrying a leather briefcase and moving with the focused energy of someone who had received a phone call she had been half expecting for years. She identified herself to Harmon, produced her bar card, and asked for his warrant in the same breath. "We are conducting an authorized warrant or administrative subpoena," Vega said, setting her briefcase on the reception desk and opening it. "One or the other. If you have neither, I am formally notifying you that this inspection is unlawful, that my client has withdrawn consent, and that your continued presence constitutes an illegal search under the Fourth Amendment. I am also notifying you that this facility has a security camera system covering every interior and exterior space and that everything that has happened since your vehicle entered that parking lot is documented in high definition." She placed a legal pad on the reception desk and looked at Harmon. "I would like your badge numbers, all three of you, and I would like the name of the supervisor you just called." Harmon gave them to her. The lobby camera captured him doing it. He and his team left Reyes Construction at 9:44 a.m. 32 minutes after entering, without inspecting a single document, without detaining a single employee, without producing a warrant that had not existed when they walked through the door. The lawsuit Patricia Vega filed in the United States District Court for the Western District of Texas was comprehensive and precise. Roberto Reyes and Reyes Construction and Development LLC versus the United States of America, Agent Victor Harmon, Agent Daniel Castillo, Agent Marcus Webb, and the Department of Homeland Security. The allegations included warrantless entry and unlawful search under the Fourth Amendment, unlawful seizure of a business premises without consent or legal authority, attempted compelled production of protected employment records without administrative subpoena, racial and ethnic profiling in the selection of the target business, deprivation of civil rights under color of law, and intentional infliction of emotional distress upon the business owner and employees present during the raid. The evidence was overwhelming before discovery even began. 8 security camera angles covering the entire 32-minute operation from parking lot entry to departure. 3 agent body cameras providing simultaneous interior perspectives. Audio capturing Roberto Reyes citing administrative search doctrine, invoking his Fourth Amendment rights, identifying his judicial background, and requesting a warrant by name 4 separate times. Audio capturing Harmon's failure to produce any legal authority for the inspection on any of those 4 occasions. The government's first settlement offer arrived 10 weeks after filing. $150,000. Vega's response was delivered in 1 paragraph. Your agents entered a private business without a warrant, attempted to compel production of protected employment records without an administrative subpoena, and were corrected on their own legal authority by the business owner, a retired United States immigration judge with 16 years on the federal bench, in front of 8 security cameras. They then left without completing any inspection because they had no legal basis for being there. $150,000 does not reflect the gravity of what those cameras recorded. We will see you at trial. The government came back with $600,000. Still not sufficient, Vega replied, and submitted her trial witness list the same afternoon. The trial opened 17 months after the raid. The federal courthouse in San Antonio was packed every day. Latino business owners attended in groups. Immigration law professionals filled the gallery. Civil rights organizations from 4 states sent representatives. National media recognized it immediately for what it was: a case that asked a federal jury whether the Fourth Amendment protects a Latino business owner on Carpenter Street the same way it protects anyone else, and whether 19 years of legitimate business operation disappears the moment 3 agents walk through a door and decide they already know what they are going to find. The security camera footage played on day 1. All 8 angles simultaneously on the courtroom monitor, synchronized by timestamp. The jury watched the agents enter. They watched the lobby containment formation complete itself in 11 seconds. They watched Roberto Reyes descend the stairs, unhurried, measured, and ask for a warrant 4 times in under 4 minutes. They watched Harmon radio his supervisor without answering a single one of those requests. They watched Vega arrive and produce a legal pad in the time it took Harmon to give her his badge number. They watched the agents leave. When the footage ended, 4 jurors were looking at the agent's table. One was shaking her head with slow, deliberate certainty. Roberto Reyes testified for 5 hours. He walked the jury through his 16 years on the immigration bench, the cases he had heard, the legal standards he had applied, the warrants he had reviewed, the administrative subpoenas he had evaluated. He described what it meant to build a construction company over 19 years and watch 3 agents walk through the front door and begin issuing commands to his employees before they had established a single legal basis for being there. "I have signed orders that required warrants," he told the jury, his voice carrying the particular weight of someone who has spoken in courtrooms for most of his adult life. "I have dismissed cases because agents failed to follow the legal framework. I have ruled against the government when the government exceeded its authority. And I sat at the bottom of my own stairs and watched 3 agents attempt to do exactly what I spent 16 years preventing from the bench." He paused. "The certificate on the wall behind me when I came down those stairs is a commission from the Attorney General of the United States. It says I was trusted to uphold the law. On Thursday morning, those agents walked past it without looking at it. But the cameras saw it. And now you have seen it too." Vega called Harmon on cross-examination. The exchange was methodical and total. "Agent Harmon, did you have a judicial warrant when you entered Reyes Construction?" "No." "Did you have an administrative subpoena?" "No." "Did Roberto Reyes give you consent to inspect his employment records?" "He did not cooperate with." "Did he give you consent?" "Yes or no?" "No." "Did he ask you for a warrant?" He made several statements about. "How many times did he specifically ask you to produce a warrant or administrative subpoena?" Harmon paused. "Multiple times." "For times," Vega said. "In under 4 minutes. On camera." "Did you produce either document on any of those 4 occasions?" "No." "Did you have either document?" "No." "Then what was your legal basis for remaining in that building after the business owner withdrew consent?" Silence. Vega let it sit for 4 seconds. The jury watched Harmon's face. "Agent Harmon, Roberto Reyes identified himself as a retired United States immigration judge within the first 3 minutes of your arrival. Did that information change your approach?" Harmon looked at the table. "I was conducting an authorized operation." "That is not what I asked," Vega said. "Did his judicial background change your approach?" Another pause. "We followed our operational protocol." "Your operational protocol," Vega said, "did not include verifying the legal basis for your inspection before you entered. It did not include producing a warrant when asked 4 times. And it did not change when the man asking you for a warrant told you he had spent 16 years on the federal immigration bench. Is that correct?" Harmon had no answer that helped him. The jury deliberated for 5 days. On the 6th morning they returned and the foreman, a retired San Antonio schoolteacher named Carmen Delgado, stood and read a verdict that the courtroom received incomplete, held silence before it erupted. "We find in favor of the plaintiff on all counts." The damages phase lasted 7 days. The jury heard from Reyes's employees, 41 people who had stood in a construction company lobby and watched federal agents move through their workspace, the fear that moved through the building that morning, the employees who had called family members, the workers who had not come back for 2 days because they were afraid of what might happen if they did. They heard from an economist about the contract bids Reyes Construction had lost in the months following the raid, the reputational damage to a 19-year-old business in a community where reputation is built one project at a time and damaged in a morning. They heard from Roberto Reyes about what it means to spend 16 years upholding the legal framework and then sit at the bottom of your own stairs and watch it be ignored. When the damages were announced, the courtroom went silent first, then loud. $1.4 million in compensatory damages for business losses, reputational harm, emotional distress, and violation of constitutional rights. $1.2 million in punitive damages directed at the institutional failure that sent 3 agents into a private business without a warrant and expected no one inside to know the difference. Total $2.6 million. Harmon was terminated. Castillo received a formal reprimand and mandatory retraining. Webb, whose body camera had captured his own visible hesitation throughout the operation, received a written warning. The San Antonio ICE field office was directed by the Department of Justice to implement mandatory warrant requirement training for all worksite enforcement operations, new protocols requiring supervisory legal review before any warrantless business entry, and demographic reporting on all worksite enforcement targets to identify patterns of selective enforcement. The agency's public statement described the changes as reinforcing existing policy commitments to lawful enforcement operations. It did not mention Roberto Reyes. It did not mention Carpenter Street. It did not mention the certificate on the wall that 3 agents walked past without reading. Roberto Reyes used a portion of his verdict to establish the Carpenter Street Business Defense Fund, providing free legal representation to small business owners facing warrantless federal inspections. He returned to his desk on Carpenter Street the Monday after the verdict was announced, poured a fresh cup of coffee, and reviewed the subcontractor bids for the municipal drainage project that his company was still building. The certificate on the wall at the top of the stairs was exactly where it had always been. The 8 security cameras still record everything. Because sometimes the most important thing a retired judge can do is descend a flight of stairs, stand at the bottom, and ask for a warrant until someone has to admit on camera that they do not have one. If you believe that every business owner, regardless of their name, regardless of their address, regardless of the language their grandparents spoke, deserves the same constitutional protection against warrantless searches, hit that subscribe button and turn on notifications. We have more stories coming that show what happens when people know their rights, hold the line, and make sure the cameras are running. Because the Fourth Amendment does not have a Carpenter Street exception. And the day we stop insisting on that is the day it stops being true for any of us.